Welcome to Solving Citizen Legal Encounters. All right, we're back in the same court again with Judge Peterson, but the sovereign citizens decided to file a motion that they wasn't going to appear. And guess what? They didn't show up. But it doesn't stop the show for this judge. So let's go in and see all the motions that they filed and see how she's going to handle them all. And we also have a second hearing where they're actually going to be in it. Let's go.
Lorenz 1, State of Nevada versus Lucia Zhang. Parents, please, counsel.
Dina Renetti for the state.
All right. And the court will note that it is currently 11:58 a.m. This was set for 9:30 this morning. And we received, and this is the reason that I am calling it last, because we received a notice of non-appearance that was filed this morning, I believe, at 6:54 a.m. It's titled Notice of Non-Appearance to the Fraudulent May 15th, 2024 hearing in brazen violation to NRS 1.2355A and NRS 1.2356. I'm going to address this first, and then I am going to address the motion to strike the late filed opposition, which the court is going to be advancing. It's set for hearing on June the 3rd. The court is going to advance that to today. And then there is the emergency motion to dismiss this entire case with prejudice for brazen fraud on the part of BCPD Sergeant Christopher Slack and Chief Deputy District Attorney Dina Renetti, that the court will address and make a record on.
I've never seen a sovereign citizen file a motion and go through with it, such as not appearing in court. He definitely has a different play on the sovereign citizen script and how they do things. But we're going to see how this hearing goes.
So I'm going to I have prepared a oral pronouncement that I am going to give from the bench. And what we are going to do, Ms. Renetti, so that there is a very clear record, is I'm going to have you do the order, but I'm going to have you order the transcript, and we are going to incorporate the transcript by reference into the order so that there is a very clear record of the ruling by the court, and so that there is no misunderstanding as to what the court is saying. So let's deal with the allegation that the court cannot hear this based on 1.2355A and NRS 1.2356. NRS 1.2355A says, except as otherwise provided in subsection 6, the judge against whom an affidavit alleging bias or prejudice is filed shall proceed no further with the matter and shall, if the judge is a district judge, immediately transfer the case to another department of the court if there is more than one department of the court in the district, or request the judge of another district court to preside at the trial or hearing of the matter. 6, a judge may challenge an affidavit alleging bias or prejudice by filing a written answer with the clerk of the court within 5 judicial days after the affidavit is filed, admitting or denying any or all of the allegations contained in the affidavit and setting forth any additional facts which bear on the question of the judge's disqualification. The question of the judge's disqualification must thereupon be heard and determined by another judge, agreed upon by the parties, or if they are unable to agree, by a judge appointed. If the judge is a district judge, by the presiding judge of the judicial district in the judicial districts having more than one judge, or if the presiding judge of the judicial district is sought to be disqualified by the judge having the greatest number of years of service. On March 25th of 2024, there was a motion to disqualify myself, Judge Peterson, for actual bias pursuant to NRS 1.230 and NRS 1.235. The court would note, for the record, that under NRS 1.235, that it says that any party to an action or proceeding pending in any court other than the Supreme Court or the Court of Appeals who seeks to disqualify a judge for actual or implied bias or prejudice must file an affidavit specifying the facts upon which the disqualification is sought. The affidavit of a party represented by an attorney must be accompanied by a certificate of the attorney of record that the affidavit is filed in good faith and not interposed for delay. The affidavit must be filed not less than 20 days before the date set for trial or hearing of the case, or not less than 3 days before the date set for hearing of any pretrial matter, except as otherwise provided in this section and subsection 3. That is not relevant. Pursuant to NRS 1.2354, at the time the affidavit is filed, a copy must be served upon the judge sought to be disqualified. Service must be made by delivering the copy to the judge personally, or by leaving it at the judge's chambers with some person of suitable age and discretion employed therein. Just for purposes of the record, 1.2354 was not complied with, as I was not personally served. However, because I pay very close attention to all of my cases, and when I saw when the motion to dismiss was going to be coming up before me, which they had filed before they filed the motion to disqualify, I refrained from acting on that, and then I saw the affidavit, or I saw their truth affidavits, and so I filed my affidavit on 3/27. Subsequent to that, the chief judge heard the motion to disqualify and entered an order on April the 16th of 2024 denying that motion. Since that time, the motion to dismiss was filed on 4/21, and there has been no subsequent affidavit or motion filed to disqualify myself and this department. The court will note, so there was a motion to disqualify, I take it back, there was an emergency motion to disqualify filed on May the 5th in regard to the, which was not served on the court, which was based on, according to the individual named in the affidavit as Kimball Austin Sachs, for actual bias based on my ultra-vires April 23rd, 2024 minute order pursuant to NRS 1.230 and NRS 1.235. And they are saying that in this minute order, which again was not served and so is not a valid motion to disqualify me and does not comply with 1.235. This is based on the email, the minute order that I sent, that where they had added, they had been sending emails to the department, and the court had told them on numerous occasions, and also mentioned it during our last hearing in March, that they were not to directly email the department, that their emails were harassing, and to stop doing it. And so I sent out a minute order telling them to not do it. That does not show bias, and so therefore the court does not find that it needs to not act upon the motion to dismiss, and also further finds that the motion was filed on the 2nd, and so the hearing was set for the 15th, and so therefore it was not filed 20 days before a hearing that is set to take place in the case. And so therefore it is not in compliance with 1.235.
Well, it sounds like his little plan is going to backfire with these motions and him not showing up. But we're going to continue listening to it so that way you have an idea of everything that's going on with all the motions he filed. So when the next hearing come up, you're kind of on time about what's going on here. So let's keep it moving.
So based on that, the court does not find that the the court does not find, based on the notice of non-appearance to the fraudulent May 15th, the court does not find that this is a violation for the court to go forward on the motion to dismiss or to advance the motion to strike, and so will go forward on that. As it pertains to the motion to strike, which the court is going to advance to today, the motion to strike is premised on the arguments that the opposition was untimely. The position of the individual who the court is going to state as the individual who is named in the motion of Yuxia Zhang, and since this was also filed in case number C343540, parens 2, and since both of the motions were filed in both cases, this ruling will also apply to that case as well. And the motion to strike is premised on the arguments that the opposition was untimely. The position of the individual named Kimball Austin Sachs and Yuxia Zhang, who filed the motion, are incorrect. EDCR 8 parens 4 provides a party 10 days within which to file an opposition. However, the criminal practice rules need to be read in accordance with the other rules, specifically the rules of civil procedure, which NRCP 1 states as follows. These rules govern the procedure in all civil actions and proceedings in the district courts, except as stated in Rule 81, which is not applicable in this case. Since this is a proceeding in the district court, NRCP 1 does in fact apply. Therefore, Nevada Rules of Criminal Practice Rule 8 needs to be read in accordance with Rule 6, which provides in relevant part as follows. Rule 6, computing and extending time for motion papers. Computing time. The following rules apply in computing any time period specified in these rules in any local rule or court order or in any statute that does not specify a method of computing time. To the extent that Nevada Rules of Criminal Procedure 8 parens 4 does not specify a method of computing time, the court needs to look at Rule 6. When the period is stated in days or a longer unit of time, you exclude the day of the event that triggers the period. And pursuant to Rule 6D, when a party may or must act within a specified time after being served, and service is made under Rule 5BDC, mail, D, leaving with the clerk, or F, other means consented to, 3 days are added after the period would otherwise expire under Rule 6A. Therefore, because the individual named as Kimball Austin Sachs and the individual named as Yuxia Zhang filed this motion, served it via electronic means, the period of time was extended by 3 days, which means that it expired on the 4th, which was a Saturday. Therefore, based on Rule 6A, or 6A1B, you count every day, including intermediate Saturdays, Sundays, and legal holidays, and you include the last day of the period. But if the last day is a Saturday, Sunday, or legal holiday, the period continues to run until the end of the next day that is not a Saturday, Sunday, or legal holiday. Therefore, since the 4th, since 3 days would have been added on, because the 10 days would have taken it to the 1st. You add on the 3 days, takes it to the 4th. The 4th was a Saturday, so the period of time continues to run until Monday, which was the 6th. The opposition was filed on the 6th, and accordingly it was timely, and thus the court denies the motion to strike. Moving on to the motion to dismiss for lack of jurisdiction, because that was originally filed back in March, and the court could not hear it as a result of the motion to disqualify. So now that the court can hear it, the court is going to address the motion to dismiss for lack of jurisdiction. The person who filed the motion named in the complaint and who the charges are pending against, both Judge Zhang and Kimball Austin Sachs, argue that the court does not have personal jurisdiction because they are dead, quote, dead corporate fictions.
Now, I've never heard that one before, but also think of it like this. We are listening to the judge without any interruptions. She's going over all the motions, and you know they're going to be denied. So let's enjoy it. I hope you got a snack, because I know this has been a little bit.
Specifically, Judge Zhang argues that she is a dead legal fiction. Defendants' contentions are generally related or similar to sovereign citizen concepts. The sovereign citizen movement is a loose grouping of litigants, commentators, and tax protesters who often take the position that they are not subject to state or federal statutes and proceedings. Sovereign citizens' claims are generally founded on misunderstandings of the Uniform Commercial Code, maritime and admiralty law, and trust law, among other things, and have been unanimously rejected by the courts. Bradford versus Kummerfeld, 2020 Westlaw 648-2980, Eastern District of Texas, May 13, 2020. Citing to West versus Bornunda, 5th Circuit, 2017. Citing to Berman versus Stevens, Northern District of Texas, June 10th of 2015. Defendants' reliance on the UCC or a so-called sovereign citizen theory that she is exempt from prosecution and beyond the jurisdiction of the state or federal courts is frivolous. The allegation that sovereign citizens are not subject to jurisdiction has no conceivable validity in American law. United States versus Schneider, 910 F. 2nd, 1569, 7th Circuit, 1990, Warsh versus Bank of America, N.A., 2013 Westlaw 6564657, Southern District of Texas, 2013. Plaintiff's sovereign citizen beliefs, even if sincerely held, do not place her beyond the jurisdiction of the court. See Elby versus Davis. Quoting United States versus Benabi, 654 F. 3rd, 753, 7th Circuit, 2011. Regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being, that person is not beyond the jurisdiction of the courts. With respect to challenges to a court's jurisdiction based on a defendant's alleged status as a free sovereign citizen, there is a dearth of law in the Nevada state courts. Accordingly, this court looks to cases from other jurisdictions. The 7th, 8th, and 5th Circuit courts and the federal district courts in Michigan, West Virginia, Colorado, Missouri, New York, and Texas have all dealt with arguments brought by Sachs and Zhang herein. The 7th Circuit has held the defense has no conceivable validity in American law. United States versus Schneider, 910 F. 2nd, 1569, 7th Circuit, 1990. United States versus Garcia, 684 Fed Apps, 589, 8th Circuit, 2017, which found without merit that the defendant's challenges to the district's court jurisdiction based on his assertion that he is a private sovereign flesh and blood man was without merit. See also United States versus Simonson, which was an unpublished per curiam decision, 563 Fed App 514, 8th Circuit, 2014, finding frivolous the defendant's sovereign citizen argument, among others, and United States versus Jagum, 978 F. 2nd, 1031, 8th Circuit, 1992, characterizing the defendant's sovereign citizen argument, among others, as completely without merit, patently frivolous, and rejected without expending any more of this court's resources on their discussion. Insofar as defendant challenges the court's jurisdiction to the use of capital letters to state his name, that contention has been summarily rejected by other courts. See Payne versus Clyda, 2016 Westlaw 491847, Eastern District of Michigan, January 6, 2016, finding there is no legal distinction between a capitalized and uncapitalized name in criminal matters. United States versus McAtee, 2013 Westlaw 3364452, Northern District of West Virginia, July 3rd, 2013, referring to the identical argument regarding the use of capital letters as lacking any basis in the law and as utter nonsense. United States versus Hood and Pyle, 2009 Westlaw 1883919, District of Colorado, June 30th, 2019, concluding that the defendant was subject to the jurisdiction of this court regardless of how his name is capitalized in any document. Likewise, defendants' attempts to differentiate themselves from the capitalized Kimball Austin Sachs or Yushia Zhang on the basis that the latter is a fictitious commercial name is without basis. See United States versus Reed, 2013 Westlaw 117-62139. See also United States versus Shine, 2018 Westlaw 4627145, Western District of New York, June 22nd, 2018, which held that identification of parties by using all capital letters is the standard formatting for filings and does not create a separate legal identity for the parties named. As the Seventh Circuit has stated, regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being, that person is not beyond the jurisdiction of the courts. These theories should be rejected summarily, however they are presented. Petitioner's claims as interpreted by the, strike that. Defendant's claims as interpreted by this court do not entitle him to have his motion granted. His reliance on the UCC or so-called sovereign citizen theory that he is exempt from prosecution and beyond the jurisdiction of the state and federal courts is frivolous. The same or similar arguments have been repeatedly rejected by other courts and are rejected by this court.
And she got to say all of that in peace. Let's continue.
To the extent that Zhang appears to contend that the use of all capital letters denotes a corporation and or a fictional entity, and that she is a non-corporate entity and therefore that she is not the defendant named in the case and the charges in prosecution have no effect upon her, a living soul, she offers no legitimate authority for these assertions. Her citations to Chat AI, Open AI, Scrib-D are not authorities upon which this court relies. The court relies on statutes, administrative code, and case law for its pronouncements and does not rely on any other sources. I also find no basis for Zhang's and or Sachs's attempts to split themselves into two different entities and assert that the entity charged is other than the person that appeared in court or that they are therefore outside the jurisdiction of the court. Based on the foregoing, the court denies the motion to dismiss on the basis of a lack of personal jurisdiction. Moving on to the motion to dismiss based on fraud by Ms. Dina Rinetti and Sergeant Slack. The argument is premised on the concept that Zhang and Sachs filed a notice of default against Ms. Rinetti for her failure to respond to the, quote, notices filed by Zhang in which filed by Zhang and Sachs in which they sought Ms. Rinetti and Sergeant Slack to state the state's damages, and because they failed to respond, that was somehow an admission that there were no damages and such the indictments and felony charges against them must be dismissed. The court will note for the record that Zhang's and Sachs's repeated assertion that the state somehow has an obligation to respond in a particular way to a particular matter to her affidavits does not make it so. NRCP 7 provides that only these pleadings are allowed: a complaint, an answer to a complaint, an answer to a counterclaim designated as a counterclaim, an answer to a cross-claim, an answer to a third-party complaint, and if the court orders one, a reply to an answer. Moreover, a request for a court order must be made by motion. To the extent that that is under the civil rules, the court understands that this is a criminal case, but that does not mean that notices are appropriate or that Ms. Rinetti or Sergeant Slack are required to respond to these notice. A notice is not any of the foregoing documents, and therefore no response is required. Nor can a party obtain a default based on a notice. Rather, a default is born out of a failure to file an answer to a complaint. As such, the court finds no basis for any obligation on the part of Ms. Renetti or Sergeant Slack to answer any of the notices filed by Zhang, and the failure to do so does not constitute a default. The determination of whether Zhang or Sachs violated the law is a determination to be made by the jury. Additionally, to the extent that they are arguing that the state did not state that it had any damages, damages are appropriate in a civil case, not in a criminal case. In a criminal case, the damage is in and of itself a violation of the law, and that is up to a jury to decide whether or not the law was violated. The court notes that plaintiff's legal theories regarding why she is not bound by state law appear to grow out of the sovereign citizen movement, which courts around the nation have repeatedly and completely rejected, as previously stated under the motion to dismiss for lack of personal jurisdiction. Plaintiff's argument here that they are not subject to any criminal laws whatsoever because of the distinction between the fictional corporate entity, Zhuxia Zhang, and all in capitals, and the human Zhuxia Zhang with only the first letter of the first and last names capitalized is nonsensical and false. Deconstructing Zhang's and Sachs's arguments would be no more fruitful than debating the number of angels that can dance on the head of the pin. It suffices to say that no court has ever found any validity in the myriad of assertions that may be classified under the heading sovereign citizen, and that Zhang and Sachs have failed to provide citation to any court decision, state or federal, which supports their assertions. The references to ScribD or OpenAI are not sources upon which this court relies. Zhang's and Sachs' claims that they are not subject to the laws of the state of Nevada because of some distinction between corporate personhood and actual personhood is totally spurious, unfounded, and frivolous. It would be sufficient to conclude that Zhang's and Sachs' allegations are utterly frivolous and end the inquiry here. However, the court makes a few fairly obvious observations for the sake of clarity and finality. First, there is no legal distinction between a capitalized and uncapitalized name in criminal matters. See United States versus McCarty, 2013 Westlaw 3364452, Northern District, West Virginia, July 3rd, 2013, in which the court found that the filing alleges that the defendant is not the person named in the criminal charges because the name on the charging documents is in all capital letters. This argument lacks any basis in the law and in the court's eyes is utter nonsense. Citing to U.S. versus Hood and Pyle, 2009 Westlaw 1883919, District of Colorado, June 30th, 2009, which held that the defendant is subject to the jurisdiction of the court regardless of how his name is capitalized in any document. Second, courts of law operate on the basis of statute and case law. There are not magic words like free man on the land, stand under, or flesh and blood, which when invoked require courts to abandon state law in favor of the magical unsourced laws asserted by Zhang or Sachs. Third, a person may not generally copyright a trademark or trademark their own name. See Turner versus Patterson, 2012 Westlaw 2792416, Northern District of California, July 9th of 2012, holding that a pro se prisoner plaintiff cannot trademark or obtain copyright for his own name. In any case, the existence of a trademark would not prevent a court from exercising jurisdiction over a civil or criminal matter. The 14th Amendment provides that all persons born and naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. At the time the felony charges were filed against Zhang and Sachs, it is alleged they committed violations of Nevada law within the territory of Nevada and are thus subject to the laws of Nevada. Based on the foregoing, this court rejects Zhang's and Sachs's arguments as frivolous and without merit. This court agrees with all the other courts that have addressed this issue and summarily rejects Zhang's and Sachs's challenges that they pursue in their pro se materials. This court is also going to take this opportunity to address the actions Zhang's and Sachs have taken that indicate the failure of Zhang's and Sachs to comply with the rules and to comply with an order of this judge. On April 23rd, 2023, the court issued a minute order telling Zhang and Sachs to stop emailing the department. Despite that court order, Zhang and Sachs have continuously added the court's email address, my specific address, at jpeterson@clarkcountycourts.us, and the email addresses of my staff to Odyssey, which means that the court is receiving the emails to the work email address in direct violation of the court order telling them to not email the department. To the extent that they are concerned that the court has not been able to see all of their filings, I think the court has made it abundantly clear that it has reviewed every single filing that has been filed in this case. The actions that have been taken by Zhang and Sachs have needlessly wasted judicial resources, and therefore the court is now issuing an order that if Zhang or Sachs adds me back personally, jpeterson@clarkcountycourts.us, to the e-service list, I will issue an order to show cause and have you brought into the court to address why you should not be held in contempt, and have the conditions of your release pending trial modified as a sanction.
The hammer's finally coming down, and that's exactly what you want. And the second thing, she has no one to argue with today. But it's almost over. I know it's been a long time, but we're almost done.
Additionally, the court has told Zhang and Sachs that they will not refer to Zhang or Sachs as attorney in fact Sachs or attorney in fact Zhang. To the extent that you argue that you are acting on behalf of a corporate fiction, you would have to be licensed to act as an attorney on behalf of a corporation. And you are not licensed as an attorney. Moreover, an attorney in fact, contrary to your protestations, is someone who is acting on behalf of somebody else. You are acting on behalf of you. To the extent that you are trying to say that you are acting on behalf of a corporate fiction, the court has already stated the reason why you cannot do so. Moreover, to the extent that you argue that you filed a nunc-pro-tunc with a T is in your filings, first of all, it is a nunc-pro-tunc without a T, which is an order that is filed by the court amending a prior order. An individual does not file a notice and then that becomes an order. So your notice of nunc-pro-tunc order is of no force and effect. Any future filings that are procedurally of no force and effect or are devoid of legal and factual merit will not be tolerated by this court. And the court will consider any future filings that are devoid of legal and factual merit, will consider issuing an order to show cause as to why you should not be held in contempt of court and issue sanctions in accordance with EDCR Rule 7.60. That is the court's ruling. The court will order a transcript to be prepared and will incorporate this order into the order that denies the motion to dismiss for lack of personal jurisdiction, denies the motion to advances and denies the motion to strike, and denies the motion to dismiss for fraud upon the court based on Ms. Renetti and Sergeant Slack failing to respond to the notices. And that'll be it for today.
And do you need the state to do anything?
All I need the state to do is to prepare the cover card that says this matter came before the court on such and such a day on these following motions. The court issued its rulings from the bench. The rulings are hereby incorporated by reference with the attached transcript as Exhibit 1.
You got it. And should I have 30 days for the transcript?
You can have 30 days for the transcript.
Maybe you just like email me when that transcript's done and then I'll send the order.
For purposes of the minute order, though, you can do a minute order that states that all of those were denied.
Okay.
Okay?
Thank you.
All right.
Filed into both cases.
Yes, please, filed in both cases. And are we off the record?
Okay, all of that is finally straight, so we caught up on the motions. You know they were going to get denied. A whole lot of points was brought up, and a lot of things are on the record. So now we have one more hearing left, where it's short and sweet, but you'll see what's going to happen. Let's go.
State of Nevada versus Kimball Sachs, correct?
Yes.
Okay. Appearances?
Julia Barker, bar number 14823 on behalf of the state.
Okay. Who's appearing for the defendants?
Attorney-in-fact Sachs for the defendant, sir.
And Your Honor, I just want to be clear about something so the record is incredibly clear. Mr. Sachs is representing himself in proper person.
Right. Mm-hmm.
He has in the past filed motions to represent his co-defendant, who is his wife, and has been denied because he is not a factual attorney.
Right.
So his wife, the other co-defendant, does have another attorney. I don't believe they are here today because I think the motion to disqualify was just filed under Mr. Sachs. So just
Okay. Briefly, go ahead.
And I'm sorry to interrupt you. I'm standing in for Ms. Renetti. She is out of the jurisdiction. I know she had emailed both Judge Weiss and Judge Peterson asking to continue this until next week.
Oh,
My understanding was Judge Peterson had agreed, and then Judge Weiss did agree by email. I don't have that email, I apologize, but that it didn't actually get updated in Odyssey. So if your court would like to hear, if your honor would like to hear argument from the parties, I would just request a continuance to next week. So Ms. Renetti could be here.
okay. So that would be the 20th, right?
I believe so, yes.
Sir, sir, I object that we got notice of this. No, it's like pulling a fast.
Okay, I can basically deem it submitted. As I looked at this, there was no hearing requested, right? Right? I'm just gonna deem it submitted.
Thank you.
Okay, and I'll issue my ruling. I don't,
Thank you.
okay?
I believe that's all that's necessary, but
Yeah.
if you.
It's deemed submitted. I'll have these items under advisement and issue my orders as soon as I can. Thank you.
Sir, do I get to make a statement?
Judge.
What's that?
Sir, do I get to make a
No, I
statement?
don't think it's necessary. Okay, thank you.
For the record, sir.
Oh, this is priceless. Is he coming back?
Okay, I'll tell you what, go ahead and make your statement.
I think he's off. Oh, no.
Thank you, sir. The statement that I want to make, there's actually a number of them because I wrote down my notes this morning very carefully that I've made an extensive record of actual bias for both of these individuals. And so the extensive record made, just to go by the dates and titles of what has been filed, for Judge Weiss, starting with Judge Weiss first, April 11th, there was an emergency joint motion to proceed in form of papyrus. And unfortunately, for whatever reason, Judge Weiss did not give us a copy of his denial order from that, which set into motion a chain of events which caused a whole lot of problems that were already described in these motions. And then on April 12th,
You've said
There
all
was-
this out, you've said all this out in your briefing, right?
pardon, sir?
You've set all this out in your motions, right?
Some of it is, but
In other words, your motion, which right on its face says hearing not requested, right?
for one of them, yes, for one of them, yes, but I lost track
That's not his fault, attorney, in fact.
of the one that I did want a hearing for, at least one of them, sir, because there were two disqualifications. There was one for
Okay.
Judge Peterson and one
I'm
for
only,
Judge Weiss.
I'm only considering the one regarding Judge Weiss.
You're only considering the one for
Yes,
Judge Weiss?
what you're seeking is just, you were seeking disqualification of other judges, or another judge, whatever. And Judge Weiss was to hear those, and then you filed a motion to disqualify Judge Weiss from hearing those motions, right?
So specific to this, then, in other words, you clarified that, thank you, is that where Judge Weiss states on his June 7th declaration in response to defendants' emergency motion to disqualify Chief Judge Weiss for actual bias pursuant to NRS 1.20 and NRS 1.65. In paragraph number 7, he states, the last sentence in that paragraph, it says, additionally, all requests for records, including copies of orders, must, they use the word must, be directed to the Clark County Records Department. Sarah, I've been dealing with this court now for almost 5 years.
Okay.
And every single time that I've received something came through Odyssey. So I would like to know under what specific NRS he's claiming that to be so.
Okay, thank you very much. The matter stands submitted. I'll review it further and issue my rulings. Thank you.
Once that judge saw he didn't want to have a hearing, he didn't want anything to do with it. And I don't blame him, because he didn't want to go back and forth. And you have a defendant that's going against other judges. They don't want to take care of that. So anyway, I know the hearing was a little rough for the first one, but we have to get through the bad to get to the good. So we're going to keep it going. We'll see what happens on the next hearings that I bring through on this case. Have a good one.
Welcome, misunderstood citizens, to the Lords of Legal Fiction, where the law is whatever we scribble on a napkin at 3 a.m. after 6 Red Bulls. Are you tired of government tyranny like stop signs, taxes, and reality? Do you believe the secret to freedom is screaming, "I do not consent," at a confused police officer? Then boy, do we have the legally binding imaginary loopholes for you. We'd like to thank our sponsor, Hutch, at Sovereign Citizen Encounters.
I'm Hutch, and I approve this message.
After graduating our masterclass, cops will be on their knees begging for your forgiveness. You learn how to deliver your rightful message with conviction and power. Never calmly say,
"I'm not driving, I'm traveling."
"No, no, no." Scream it like you mean it. Enroll in our Lords of Legal Fiction masterclass to learn how to turn every traffic stop into a constitutional crisis and every courtroom into your personal improv show. Why pay a lawyer when you can just cite maritime law and accuse the judge of being a hologram? On sale now is our Sucker Bundle. You get one US DOT license plate, one attractive and sturdy license plate holder, one legal-only to you passport, and these impressive sheets of constitutional law that you can give to your rights-busting cop. Act now, and you can be impervious to the law and courts. You can even tear the tags off mattresses without the threat of punishment. Seriously, don't let this once-in-a-lifetime opportunity slip away. Offer not valid in 48 states. Some assembly required. Member FDIC. Batteries not included. May cause nausea and headaches. Sofenery is addictive. If you need help, call Jail Me Now at 1-800-555-1212.